All right, welcome to The Explainer. Today, we are diving into one of the most brilliant, kind of sneaky, procedural moves in Australian legal history. It's a strategic masterclass that, honestly, every single aspiring barrister needs to have in their back pocket.
So let me ask you this. Imagine you're in court. It's a landmark case and you are winning. Things are going your way. Why on earth would you stand up and ask the judge to just stop the whole thing? It sounds crazy, right? Well, that's the puzzle at the very heart of the 1994 Wik Peoples v. Queensland case.
So here's what we're going to do. We're going to unpack how this incredibly strange request was actually a stroke of absolute genius, and we'll see why getting your head around this case is so critical, especially if you're gearing up for the bar exam.
Okay, let's set the scene. The year is 1993. The Wik Peoples are in the federal court fighting a huge battle for the recognition of their native title. And then, right in the middle of all this, a brand new law drops, the Native Title Act 1993. And this thing just completely changes the game. So instead of charging ahead, the Wik Peoples legal team does something that seems completely backwards. They ask the judge to hit pause on their own case. You can just imagine their opponents, right? Totally baffled. They're arguing, no, this will just drag things out. But the Wik team, and importantly the Commonwealth, insisted this pause was absolutely crucial to their entire plan. And here's why. The reason for this strange move had nothing to do with the facts of the case or the evidence. Nope. It was about something much, much deeper. Something every barrister has to grapple with. It's the difference between just getting a win and getting the win, the one that actually matters in the long run. To really get what they were doing, you have to understand a fundamental concept in civil procedure, the massive difference between a judgment in personam and a judgment in rem. Think of it like this. In personam is a personal win. It's like a private contract. It only binds the people in that room. But in rem, that's a judgment about a thing, in this case, land. It's like a public title deed. It binds the entire world. And that's exactly what the Wik Peoples were after. They didn't just want a piece of paper saying Queensland had to respect their title. No way. They wanted a declaration that was final, that was conclusive, and that was binding on everybody for all time. They were fighting for that powerful judgment in rem. So this put the judge, Justice Drummond, in a really tough spot. The whole strategy hinged on one question. Could this shiny new Native Title Act even deliver this kind of super powerful world-binding judgment? Everything depended on his answer. Now, to figure this out, he didn't just look at recent Australian law. He dusted off the history books and went all the way back to an English case from 1870, Kastreek versus Imrie. This old case established the classic, time-tested way to figure out if a judgment is in rem, or, as the court elegantly put it, whether it's conclusive against all the world. And that historical case basically gives us a 4-point checklist. For this new act to pass the test, Justice Drummond had to tick all 4 boxes. 1. Is the thing, the land, actually here in Australia? Yep. 2. Will the judgment decide the status of that land? 3. Did Parliament specifically give the court power to do that? And 4. Is the court acting within that specific power? So the million-dollar question was, how does a 124-year-old English legal test apply to this brand new piece of Australian law? Well, this is where the real legal detective work kicks in. Justice Drummond started looking at the nuts and bolts of the new act, and he saw all these clues. The act required public notification. You had to tell anyone who might be affected. It created a public register for everyone to see. It forced the registrar to tell the state land titles office about the decision. All these little procedural steps pointed to one big conclusion. This wasn't designed for a private fight. This was a public process meant to change the status of the land itself.
So, after putting the new act through this historical 4-point test, Justice Drummond finally reached the conclusion that would prove the Wik Peoples' gamble was a brilliant one.
He found that yes, a decision made under the new Native Title Act would absolutely be a judgment in rem. It ticked all the boxes. But, and this is the crucial part, a win in the case as it was currently structured would only ever be in personam. It would bind Queensland, sure, but it would leave the door wide open for future challenges from anyone else. And you don't have to take my word for it. The judge himself confirmed how smart this move was. He wrote that the advantages of getting that in rem judgment were, and I quote, so important, that pausing the case was the right call. The adjournment was granted,
The path was now clear for the Wik Peoples to chase the win that really mattered. So what's the big takeaway from all of this? I mean, why is this one procedural ruling from 1994 still popping up on bar exam prep materials? Because it's a perfect bite-sized lesson in high-stakes litigation strategy. Honestly, this case is pure gold if you're an aspiring lawyer. First, it forces you to master that in personam versus in rem difference. It's not optional, it's fundamental. Second, it proves that a quick win isn't always the best win. Strategy is way more important than speed. It also teaches you to look for the hidden power of a law, not in the big pronouncements, but buried in the procedural details. And maybe most importantly, it shows you that civil procedure is not some dry academic subject you just need to pass an exam on. It's a weapon. It's a toolkit for power. It's how you control the entire game. So this all leaves us with one critical question that every litigator has to ask himself. When you walk into that courtroom, what are you actually fighting for? Are you just trying to beat the person sitting across from you, or are you fighting to secure a victory that binds the entire world? The lawyers for the Wik Peoples knew exactly which one they wanted.